Hello and welcome to this joint ProCon Leicestershire and Nottinghamshire webinar. I'm Will Kersham and I'm the chair of ProCon Nottinghamshire. As many of you are aware, ProCon has been connecting professionals in property and construction since 2000 in Leicestershire and 2018 in Nottingham. We hope that many of our members have joined us today to listen to this webinar, and we welcome anybody new to ProCon. We're always looking for more people to join the network, so if you're not a member and are interested in finding out more, it's easy to get in touch with us, so please do make contact with us via the contact details on the screen now. We will also email our contact information for ease after this webinar. Today, we're going to be looking at the legal and contractual impact of the coronavirus pandemic and what the property and construction industry has learned from it so far. For many in the property and construction industries, work has carried on relatively uninterrupted, but under very different circumstances and with a number of new obstacles. Contracts have had to be renegotiated, payment terms and additional costs discussed, supply chain issues overcome, and new health and safety measures implemented to make sure the workforce is as safe as possible. And that's all while ensuring customer expectations and deadlines are still met. This afternoon, our speakers Piet van Gelder of Gateley Legal and Darren Eaton of Morgan Sindall will be discussing these challenges in greater detail and share some practical examples they've dealt with over the past year. We'll also be looking forward at how the lessons we've learnt might be implemented in the future. As always, we'll be hosting a live Q&A session at the end of the webinar with assistance from Cartwright Communications, where Pete and Darren will answer your questions. If you have a question for either of them, simply type it into the box below and we'll be answering these in a little while. You can also use the upvote function if you see a particular question you'd like to know the answer to. So please make use of this, as we'll be able to make sure we answer the questions that you're most interested in. But now, without further ado, it's time for me to hand over to our first speaker this afternoon, Piet van Gelder.
Good afternoon to ProCon Leicester and Nottingham. We're here today to talk about the legal and contractual impact of COVID. My name's Piet van Gelder. I'm a partner at Gateley Legal, specialising in construction engineering. And I'm joined by Darren Eaton of Morgan Sindall, who's going to give a practical example of where Morgan Sindall was able to work to resolve coronavirus problems. So what did coronavirus mean for construction projects? I want to look at this in three sections. I want to look at the onset of coronavirus and what it meant for construction projects in the immediate term. I then want to have a look at the issues surrounding coronavirus that were pertinent right at the start and continue to be issues that need to be resolved during current problems, and then see what can be done to mitigate the long-term effects of coronavirus. To turn to the first question, what did coronavirus mean for construction projects? Construction projects and the contracts that regulate them, which is what I do, are usually absolutely fine most of the time, even 95% of the time, like I put on my slide. People are commercial and get matters resolved without needing to get too formal about those arrangements. Generally, where issues do arise in construction contracts, they can be lumped into four different categories. There's additional works and their impact on time and cost. There's delays to the project and the time and cost impact of those. There's defects in the works, and there's unforeseen issues that crop up and impact all the above categories. Usually, unless something really major happens, people use common sense and work together to resolve issues collaboratively. But something very unusual and unexpected did happen in March 2020. You can see here the doomsday scenario of coronavirus making its way towards Earth. Now, it's not quite a meteorite, but the impact of coronavirus was very, very serious for construction projects. In March 2020, coronavirus cases were increasing and constraints were put on socialising that rapidly escalated into a full lockdown that no one, even a week or two before, had previously expected. No contracts negotiated towards the end of 2019 or in the early part of 2020 could have foreseen a coronavirus lockdown. And in fact, there were a lot of projects that were of long standing that were negotiated well before anybody had even heard of the phrase of coronavirus. What did it actually mean? Well, it meant there was widespread deprivation of liberty. There were constraints on freedom of movement. There was a contagious pandemic rife within the community. There was unclear and reactive legislation brought in at breakneck speed. There was uncertainty as to whether projects would be happening the next week or even the next day, because businesses were closing down on an almost daily basis. And this meant there was an inconsistent approach of the supply chain, especially those international suppliers in fields such as tiling. No contract properly legislated for this sort of impact. It's one of those sorts of things that you say, right, if I'm trying to apportion risk in the contract, I understand the normal parameters that we need to deal with when dealing with construction projects. And then something completely unforeseen happens. And that's when actually serious issues can occur, because the contracts don't really legislate for them. The question was, who was going to pick up the pieces and how? Almost overnight, the people on the ground had to radically adapt their way of working to comply with the government legislation and also the health and safety issues to try and keep their employees safe and stop coronavirus running rife all the way through their construction staff. For the first few weeks, there was uncertainty whether construction sites would be permitted to remain open, as a lot of other industries weren't. For UK-based suppliers, there was a difficulty in determining whether they could still operate to manufacture or supply goods and do so safely without compromising their staff. There was a raft of international restrictions imposed by different countries, which affected the construction supply line coming into the UK. And the culmination of all this was the project timescales pretty much went out of the window. And from a legal point of view, that not only had a localized effect in terms of construction contracts, but also had a knock-on effect in real estate and finance agreements, which often were tethered to the achievement of completion or the progress of these sorts of projects. All of this equated to more time and therefore to increased project costs. And the question was how that was going to be managed. There were a lot of phrases bandied about at the time then in March when coronavirus first came to light in a serious way. And a lot of clients asked me about force majeure and whether it could be used to try and apportion risk and resolve contractual issues. Now, force majeure is not a common law right that just exists in isolation. It actually has to be part of a term of a contract. Some contracts contain force majeure clauses, some don't. If there is an undefined right of force majeure used in the contract, then there is no recognised meaning in English law. So actually, the fact that it's even included in the contract doesn't necessarily mean it's going to help very much. A common understanding of force majeure is that it is an unexpected circumstance outside of a contracting party's reasonable control. And I think it's safe to say that certainly for the majority of construction contracts, the coronavirus lockdown and the associated issues with that were not foreseeable. Unfortunately, English law is fairly scant on this. There was reference in the Clifford case to a flu pandemic as an event of force majeure, a downturn in financial markets, which is maybe a consequence of the pandemic, certainly wasn't a force majeure, and the fact that the contract became more expensive to perform definitely wasn't a first force majeure issue either. On top of that, although the lockdown actually occurred in March 2020, it was foreseeable from February 2020 that coronavirus would have an impact on construction contracts. So although the severity of a full lockdown may not have been in people's minds, they were still saying, well, look, there could be disruptions to the supply chain as there were effects on businesses. And you could see around Europe, the various countries were having to take increasingly stringent measures to try and prevent the spread of the pandemic. Now, the force majeure event itself may not in fact be the COVID-19 pandemic, but the consequences arising from it. Delayed materials, no availability of materials, no availability of labour. So therefore, people should be putting requests in for an extension of time. And if people wanted to rely on a force majeure clause, then the question was, what effect would it have on the funding agreements and other third-party agreements, like the real estate ones I referred to? Would it trigger a right to terminate the contract, or might it even trigger a right to terminate those third-party agreements? Can the person claiming the extension of time actually provide a causal link between force majeure and delay to the works? It might be straightforward if the majority of the workforce is required to self-isolate, but less straightforward if there's a supply chain issue. A lot of people have said, well, the works are delayed because of the coronavirus, but actually that doesn't really help you in terms of trying to assess what the impact is. And it's important that you have to try and realise how long it is anticipated that the force majeure event will last for. And having people, in fact, when they made notifications, actually made proper allowance for the long-standing effects of coronavirus. Another issue from a legal perspective was frustration. People said, well, the coronavirus has frustrated the contract, therefore I'm no longer obliged to go and perform it. Now, frustration is when a significant change in circumstances makes the contract impossible to perform, illegal, or radically different from what was envisaged without the fault of the party seeking to rely upon it. That is a common law right that exists on its own outside the contract. The application of frustration in the circumstances of the coronavirus is likely to be limited, as a contractor cannot claim frustration where the parties have contractually agreed the consequences of the supervening event. That's where the force majeure clause comes in. If the contract has not yet been formed, if there's an alternative method of performance, which largely is the case with construction projects, that performance has become more expensive, or because one party has been let down by one of its suppliers. Now, frustration allows the parties to be discharged from further performance of their obligations and not be liable for damages for non-performance. But if you choose to use it, the contract is permanently finished and cannot be resuscitated. Other people said, look, I don't want to actually terminate the contract fully, but maybe we should suspend it until we understand what the real impact of coronavirus is going to be on how we actually manage these construction projects. Again, there is no common law right to suspend performance. And so you have to look at the contract. If we look at a popular contract such as JCT, an employer can suspend under clause 310 or order a change under clause 5.1 to omit works, impose obligations or restrictions on the access to site, working space, working hours, or on the execution or completion of the work in a specific order. By contrast, the contractor can suspend for non-payment, but that's not largely going to be the case in coronavirus. It can also claim for an extension of time under clause 226.14 and a consequential claim for loss and expense under 421.5. Or it could terminate if the contract is suspended by an instruction of the employer for 2 months. The contractor could potentially put pressure on the employer to instruct a suspension by appealing to the principal designer that the continuation of the works is a health and safety issue, and that's certainly something that has to be taken account of. Or argue that the employer's reluctance to instruct a suspension is an impediment, as the contractor now has to complete the works under new methodology, which effectively was the case, because effectively trying to work on a site with a workforce during the pandemic means there are far fewer people who can work in such proximity to each other, and different methods will need to be employed. What about coronavirus and health and safety? An employer has a number of duties. Those are usually enshrined in the Health and Safety at Work Act 1974 and the CDM regulations. If the client is aware of these duties but doesn't adhere to them, there is a health and safety breach under the regulations. And this can itself lead to a suspension under a contract such as JCT. The contractor also has the right to terminate if the employer fails to comply with the CDM regulations and does not remedy that breach. As a consequence of either termination under clause 8.9, the contractor will be entitled to any direct loss and expense or damage under clause 8.12.4. If, however, the employer makes appropriate health and safety measures, there can be no claim to the employer for impediment or default, and no contractual right to suspend the works. So there is an even balance in that situation in terms of dealing with health and safety, and it's important that all parties and stakeholders in the construction project actually work together to try and maintain a health and safe environment. We've had a quick look at the JCT. It's also worth having a look at the NEC4, especially as it's a popular contract in public works. The NEC4 has no definition of force majeure, but does have a definition of prevention, which is an event that stops the contractor completing the works by the planned completion shown on the accepted progress. If there is a prevention, it's up to the project manager to give an instruction. There is a right to a compensation event under clause 60.119. Also, a change in law or exercise of a statutory power which prevents performance could fall into the above criteria of prevention. There is also an optional clause X2 which expressly makes a change in law after the contract date compensation event. This can be triggered by the passing of emergency legislation, and that's still a live issue now when you see that effectively lockdowns can be brought in very, very rapidly indeed. The client has a right to terminate for an act of prevention or force majeure, and there is a mutual right for parties to terminate where the parties have been released under law from performance of their obligations. But this is problematic if those changes are only temporary. I wanted to have a few slides here from a contractor's response, which was sent almost immediately after the coronavirus issues reared their head in March 2020. It comes from a local contractor, and it sent a circular out to all of its subcontractors regarding the COVID-19 break, and asked them to complete a letter setting out what their problems were going to be and suggesting clauses that they could use under the subcontract to deal with the effects of the coronavirus. I'm not going to read these out. I'll leave you to look at them at your leisure. Now, a lot of parties did try to get ahead and manage risk, and the above documents show how that is done by one particular contractor. It is proactive in getting the subcontractors to communicate and set out their difficulties and make an assessment about how they will affect the timing of the project and possibly the cost. They're based on JCT subcontract terms, and the letter itself sends the subcontractor down a route where effectively it notifies relevant events, but relevant events which do not have consistent relevant matters. So the effect will be to potentially allow the subcontractor an extension of time, but not less an expense. This will allow the contractor to have discussions with its clients on the basis that it will get time, but not money. And to the extent that that contractor could actually get money, then effectively it would be able to keep that money and it may not necessarily have to distribute it in the subcontract tier. Obviously, there are different ways of dealing with these problems, and Darren, in the second part of this presentation, will talk about how Morgan Sindall dealt with this approach. In terms of practical considerations, for a pre-contract, there could be a decision between the parties to defer the works if they can, and if the finance is still available. And it gives an opportunity to renegotiate the terms. So effectively, when they go in to the project, then they have realistic timeframes, realistic costings, and there should be fewer problems during the course of the works. The question to be asked is whether a mechanism can be agreed to try and manage costs in a defined way, or with a cap so there's a share of the risk, the consequences of sharing the risk are visible and capable of better assessment. For example, one subcontractor who had a major contract in London that I assisted with suggested having a quasi-suspension for coronavirus and having defined uplifts in terms of the costs and a defined window of delay, and then effectively take on the risk beyond that. That same subcontractor was also concerned about fluctuations in the current pricing. At the moment, there is fairly low interest rates, but there is a serious risk that the government will introduce quantitative easing, and that will often have a upward pressure in terms of interest rates. So going forward, contracts that are just come into force and may last for a year or so may actually have quite serious fluctuations in terms of the cost of labour, material and plant. In terms of practical considerations post-contract, you need to ask yourself whether or not proper extension of time, lost, expense or compensation event claims have been made, and whether or not early warning events have been raised to allow people to manage them effectively. A key theme in terms of resolving problems without falling out is to make sure that you work collaboratively and have early warning or risk management meetings to identify issues and agree a way forward. For example, the employer could decide, well, actually the cost of the project are massively increasing. Should I actually go and procure free issue material more than I expected, or procure more major items to lessen the impact of cash flow on particular contractors so they're kept stable? The other question is, is coronavirus itself really the cause, or is it something else that's in fact been causing critical delay? And that's why there has to be a sort of causal link. The fact of the matter is that there may be a delay to the project from a previous subcontractor, for example, that impacts on the next subcontractor. That in itself is not going to be coronavirus, it's going to be delayed by another subcontractor. That may in turn have been caused by coronavirus further down the line, but it's not something that is actually relevant to that direct act. Do the parties have a clear understanding of what the consequences for delay and working methods entail? Has the contractor accumulated sufficient evidence and substantiation of what is being claimed and the potential effects to allow genuine assessment of time and money? Remember, this is a very unusual situation, so actually having that evidence and really be a stickler for being able to build up the claims for additional time or additional money is going to be very important because it's such an unusual situation. And have the parties collaborated to produce an updated programme to understand the critical path and mitigate delay? I hope you found that useful, and that I understand that there will be a question and answer session after Darren has gone through how he managed to resolve an awkward situation for Morgan Sindall by working collaboratively. I'll pass you over to Darren. Thank you.
Good afternoon, really good to be able to come and speak to you. My name is Darren Eaton from Morgan Sindall, and I'm just coming to talk to you about COVID and the legal and commercial challenges that we faced on one particular scheme as a little bit of a case study for you. So the scheme was right in the middle of Nottingham city centre, just across from the train station there, 319 apartments for an organisation called Vita. And as you can see, if you sort of go around that area, the scheme is complete and looks really, really good now. So high quality scheme, £24 million. And we started in November 2018. And there was basement construction and quite complicated because we basically have the tram one side of the site, the railway station the other part of the site, and there's no direct vehicle access to the site. So I guess relative to the scheme, it was a complicated scheme in the ground anyway. And by the time we kind of got to December 2019, we were really motoring. Probably a couple of weeks behind our target program. We were on line with the contract program, and things were going really, really well. We were kind of progressing internally, started doing the plasterboard, etc., etc. And then obviously February, March, we start hearing about COVID, and it starts to become a bit of a challenge for us. And as most of you will live through and kind of experience your own individual challenges, our site at Vita Nottingham was no different. So as I say, the show was nearing completion. We're starting to motor on the fit out. And in terms of value, we're about 70% through. So 70% of the contract sum had been spent. And then the 16th of March it is. And completely obviously changed the landscape at that time relative to COVID. And I guess we kind of entered into a bit of a situation where sort of, shall we carry on? Shall we not carry on? Do we go to site? Do we allow people to go to site? And it was kind of a bit of a in-out shuffle, really, a bit of limbo land occurred, particularly as we started to get towards kind of the government announcements and the COVID kind of briefings, etc. So around the 16th of March to the 23rd of March, it was a real challenge to know exactly what to do and how to progress. So our first real sense of the direction that we needed to take was obviously when the government came and said construction sites could keep working. If people were allowed to work from site, then they could, but very much complying with the COVID rules. And great hats off to the CLC, who kind of very quickly produced their guidelines and helped us to really understand what that meant from a construction point of view. So the 2 metre rule was really evident at that point. So we've got a site, we're motoring on the site, we get to kind of almost like a full stop, although we never actually close the site. And then we start to understand the implications of what COVID would do. So we've got, in effect, a building, and we're entering a building which is very sort of boundaried in terms of physicality. We've got one staircase, which obviously creates a challenge for us in terms of keeping people 2 meters apart. And I guess fortunately though, we've got a lot of small rooms where people can work on their own and very easily sort of continue to social distance. So what do we do as a business from a legal and commercial point of view? So we kind of go into what were the next steps, or kind of understand what the next steps were. And obviously the key to us, and the bit that nobody kind of can forget really, was to ensure the safety and the well-being of all the staff who are on there, our management staff, our directly employed people, but also the supply chain staff. At that point, we've got somewhere in the region of best part of 190 management and operative staff on site. And when we actually did our calculations, we were only able really to accommodate 80 staff at any one point, or 8 operatives working on that site. So that's kind of the challenge. What else did we have to do? So really, the key for us was reviewing the supply chain difficulties and understanding how they would continue their work, because Morgan Sindall construction business, like most construction businesses now, we're only as good as the people that are kind of coming and doing the work on site. So we had to understand what their blockers were, what were the issues that they were suffering, both commercially and legally. And there was a lot of really good work relative to what was happening there. So our key activity at that point was putting plasterboard on walls, and we needed a large amount of plasterboard to keep the site running, to keep the project running. And as a business, we got a good relationship with British Gypsum, to a point where British Gypsum actually opened their production facility, because we could give them a sense of how much quantity we needed. So that was really important to us, that we made sure, not just working with our kind of second tier supply chain, but also the third tier manufacturers, so they understood what was required. We also found some odd little sort of foibles. So we had a petition company that came from the south, generally worked in London, and were lodging people on our site. And that became really difficult, because in effect, all of the hotels in the local area closed down as well. So we kind of got on board with our general hotel supplier. We have a travel desk type organization, and they came on board and found the hotels for our guys to stay in. So it's a real kind of sense of, during that initial part of making sure that we're collaborating with people, making sure we're able to progress the site, and kind of removing the blockers, so that we could really understand the real key commercial issues that were occurring. In effect, our site managers and project manager was trying to move the blockers in a real kind of sense of working together way. So hand in hand with them, working alongside our commercial department, working alongside the QSs on the project, is to make sure that you kind of remove the real blockers, as opposed to people that are just struggling because they can't sort themselves out, or they can't get the project moving. So we obviously had to issue the standard legal kind of documentation. We issued notices at that point, both upwards to our client, but also downwards to the supply chain. And downwards to the supply chain was probably the most difficult part, because we wanted to feel as if we were being reasonable, and we wanted to work with them. But what we couldn't afford for them to do is to kind of fall on the difficult bit of, it's too difficult to get to site, or it's impossible for us to be able to kind of make progress. So I guess our steps around that point were literally daily meetings, really understanding what was happening on site, trying to remove the blockers, but also understanding that from a legal and commercial point of view. You know, what notices do we need to send out? What messages do we need to give, both upwards and downwards in the supply chain? So I guess having weathered that initial storm, if you like, that first 3 or 4 weeks, where I know a lot of people working very, very hard to understand how these things go together, and how we kind of operate in this kind of pandemic world, if you like. The next step was really for us to understand what has been the commercial and legal implications of what's happened. So in effect, what we did at that point was to really get a sense of estimating what the unknowns were and measuring what the knowns were. And in a very quick sort of state of affairs, really, probably between weeks 4 and 8 of the pandemic, so probably towards the middle of April, we kind of got in a sense of, well, what is this going to cost? We were heading to a completion in July, because it's a student accommodation block, and that's desperately when they need it. So what what do we need to understand relative to how are we going to finish this project based upon the new parameters that have been put in front of us, off in the production, having lots of blockers, requiring particularly COVID measures such as extra cleaning, bigger canteen, etc., etc. So I guess at that point we kind of decided that we'd sort of try and run alongside both aspects, so down the line in terms of our supply chain and up to our client. So we kind of made the decision to set out on an NEC type claim. So we had an understanding of what the program implications were of all the things that had happened in the 4 weeks, how that was going to then impact us going forward. So we could understand what our prolongation costs were. We understood some of the measures that we're going to put in, and therefore understood how we could cost some of those measures. And then really kind of getting on board with the subcontractors and understanding what their costs were going forward. You know, what is it going to take for them to be able to finish this scheme for us? So that was a mixed bag. You know, we had some subcontractors that were really, really clear and very enthusiastic in helping out. You know, we'll change shifts, we'll kind of put on a night shift, we'll develop our bit of the scheme in this way. And to be honest, we had some subcontractors that went completely the other way, almost kind of closed shop. We don't want to talk to you. We'll kind of give you a claim when we've got to the end of the project. We're not going to talk. We're going to kind of close off to any kind of communication. So we had to kind of deal with people in slightly different ways, which brought challenges. One particular subcontractor we had to part company with, and we wanted to do that in a way that didn't impact our reputation or didn't put us into the sort of threats of social media action and all those kind of things. So it's about commercially and legally trying to kind of understand how those two things go together and try and plot a way forward that maintains both our clients' progress, but also our reputation, and more importantly, the health and safety of all the people on the site. So now we've understood really what the cost is, and we also have kind of worked out what the program implications are of the 6 to 8 weeks and then going forward. We now understand what we believe we need in terms of entitlement. So this isn't kind of going to be a small amount of money. This is kind of quite a significant amount of money and quite a significant amount of time. So in terms of thinking about upwards and sort of speaking to our client, our process was very much issue some clear and concise information. You know, what has been the impact? How have we dealt with it? You know, sort of cause and effect type claim preparation, if you like. You know, what's the impact to you as the client, and what's been the impact to us? And then starting to understand each person's legal position. So understanding our client's legal position and what advice they're getting from their solicitors, lawyers, commercial people, and what information are we getting? And very early on, there was a sense that those two bits of information were quite sort of opposite ends of the scale, if you like. We were kind of feeling that the advice we were getting was, we've got a massive sort of ability to be able to claim, and likewise our client was getting complete opposite sort of end of the spectrum. And I guess when you get into a scenario like this, you're kind of going to be in that position, if you like. So we had to make sure that we understood what our position was and what we were trying to get out of. And the one thing that kind of definitely developed on this project was this understanding of mutual benefit. You know, what is the mutual benefit between us and the client? What are we both commercially and legally trying to achieve here? Not just for us, but also for our supply chain partners. You know, we've kind of come in and helped us along the journey. What are we trying to achieve? So I can remember all of our sort of offices were generally closed. We'd kind of told people in our offices to work from home where they could, people like design managers, document controllers, etc., etc. So we kind of had these empty offices, open plan offices. And we very much agreed with this client that we would one day have literally a face-to-face meeting in times when face-to-face meetings were really, really challenging. And we all kind of stood at different ends of an open plan office. It was almost like one of those meetings where you kind of, it was like a standoff at dawn, but not really. And we kind of really just laid out on the table, what is the situation? Where are we? What are we going to achieve? And very much we were of a position, we've got a big bill, and we've also got a program that's showing us completing kind of end of October, beginning of November, because of the impact of reducing the staff on that site so significantly. But quite quickly, within kind of a space of time, we understood each other's sort of mutual benefit, if you like. If we could get as many of the student units complete and open in time for September, for when the student intake is, then that would provide a massive benefit for them, and also take quite a lot of pressure off them in terms of their funder. So there was this sense of all parties would benefit if we could work together to develop kind of completing some of the units and as many as we could by September, and then as quickly as we could finish the rest of those. But that comes with a cost. I think what our view was that if we continued in the way that the contract was set out to kind of mitigate costs as much as possible, the scheme would finish somewhere in the region of kind of end of October, beginning of November. So we kind of started to talk about what is the possible here, what can we achieve. And within kind of a couple of hours of kind of stood at these different ends of the offices, we actually realized what each one of us was needed to achieve and where we needed to go with the scheme. So I guess at that point, we agreed to complete 250 of the units, of the 319 units, by the sort of second week in September, to allow them to move students in, and then we'd follow up with the rest of the scheme. And it was a real sense of none of us came out winners and none of us came out losers, but we had agreed a way forward that in effect provided that kind of mutual benefit. So how did we then kind of close that off? Well, we decided to encapsulate that in a deed of variation, and we had an agreement between ourselves and the client. We'd looked at the LADs, we looked at all of the contractual provisions relative to being able to be in that position where neither of us would be mainly benefiting, neither of us would be mainly losing out, and both parties then agreed that that in effect deed of variation, and we signed the deed of variation. So in summary then, what are the lessons that we learn from that? What are the commercial and financial lessons that we learn from something like COVID? Because next month this could be the similar thing on Brexit. There's still lots of unknowns around that, and we don't know this is the only pandemic we're going to have. Let's hope it is, but we don't necessarily know. So what do we learn from kind of, I guess, situations that are completely unprecedented, that have a major impact in the project, and how do we take that forward? I guess the first thing to do is to take time to properly identify the specific issue, really understand what's actually happening, understand where the blockers are, understand where people are kind of doing their best, or people are kind of falling away from the project because of the risk, etc. So really understand that, and then being able to proactively manage that sort of second and third tier supply chain. People can't go and fix material that isn't there. So how do we get material there? How do we sort of progress that in a way that it doesn't negatively impact on any particularly? And then seek head-on discussion around the entitlement at the point where there's still the ability to get mutual benefit. There's still the ability where both sides can kind of win out of the situation, and not kind of fall, one side having the impact and the other kind of not having as much of an issue, if you like. So that mutual benefit issue, what's the best position for both of us to achieve out of this, and then try and encapsulate that within the legal contract, if you like. Try and get that back to where we were originally and where the risks sat originally. So I guess that is kind of a lesson in collaboration, the full project team taking responsibility for an issue, taking responsibility for a massive kind of delay to the project, so that we all kind of walk away having sort of got a little bit of what we want from what is a really, really difficult situation. I think going forward, it's be unfair, really, and I guess to really kind of drive home, both from us and our clients' point of view, we both come away with the same thought, that actually not one person should be able to take the risk of something like this. It's unfair to expect one person, either that be the main contractor, that be the employer, or that be the sort of tier 2 and tier 3 suppliers, not one person can take the full responsibility for something as huge as this, because it just won't work and you won't achieve the sort of, the mutual benefit to all parties. So I guess that's what we've learned from COVID. Brought out the worst in people, but actually in our case on this particular project, it probably brought out the best in the guys that were working on this scheme, and in sort of working as a collaborative team. It's been a real kind of eye-opener as to how people can work together.
Some really, really interesting thoughts from both Darren and Piet there. Thrilled to say that they have joined us live for our Q&A now. Thank you both for taking your time on this busy Thursday afternoon. Nice to see you both. So we're going to get stuck into the Q&A now. If you would like to ask a question of either Piet or Darren, please do type them into the Q&A box below, and we'll make sure that we put as many to them as we can before we finish the webinar at 3 o'clock. But for now, we will get stuck into a few initial questions. So Piet, I'm going to come to you first for this. One of the, let's face it, very common words used to describe this year has been unprecedented. So given that you work in an industry that heavily relies on the concept of precedent, just how big a challenge was it for you and the team at Gateley?
Yeah, we perceived it to be quite a major challenge. I mean, when you have something so different that impacts construction projects, you have to think very quickly on your feet, because we imagined that there would immediately be a lot of questions asked from our developer clients, asked by our contractor clients, our subcontractor clients, our consultant clients, saying, well, look what's happened. Clearly, all of these projects are going to delay, they're going to extra cost. How do we actually manage it, and what actually do these contracts mean? So we very quickly sort of looked at getting information out in terms of practical steps on particular types of contracts, so that they could understand what methods were available to them to resolve disputes, and also have a think about how we work with them to try and communicate with whoever they were in contract with. And obviously Darren has talked about his situation with Morgan Sindall, so he's, as a main contractor, stuck as rather a piggy in the middle, having to deal with the main client, and also a huge subcontract here of people all making all sorts of different demands and all having different dynamics to their business. So it's not an enviable task for Darren at all.
Well, it sounds like they navigated it rather well, though, in his presentation, I'm sure. Now, Darren, we're going to come to you for this one. Let's throw it all the way back to the start of the pandemic, which in some ways feels like yesterday and in some ways feels like a very long time, depending on what mood you're in, I'm sure. How difficult was it to navigate the fairly inconsistent messaging from the government, particularly in those early stages where things were so uncertain?
I think the thing to do is to pause, is not to kind of rush into making decisions. And I think quite a lot at that time, people were really kind of in a sense of, we've got to do something. And it was almost kind of the situation where it was, and we had some really good leadership internally, where it was kind of, let's pause, take stock, let's not make any sort of quick decisions. As long as we're keeping people safe, ultimately, that's the key thing. So I think there was a lot of good advice, a lot of wise heads, if you like, within the industry. I think within the construction industry, we're used to things kind of almost going wrong, not necessarily on this scale as Piet mentioned, but we're generally used to having to kind of plan and replan and change things, etc., etc. And the best way to do that is just to kind of pause, take a breath, let's actually think. And I think there was some really good work as well coming through from both sort of the government in terms of construction particularly, and also from the CLC, who kind of really got together really quick. Kind of the industry worked really well in kind of coming together and developing the guidelines so that we could all really continue and carry on forward. So I think it was kind of a real collaboration of lots of wise heads, if you like.
The word collaboration is another one that I think will be used to kind of sum up this year, because in a lot of the webinars we've done, there's been a lot of talk of collaboration and that kind of sense of teamwork. So I suppose that is a good thing, isn't it, that's come out of this year. Now, Piet, I'm going to come to you for this one. In your presentation earlier, you mentioned the rapid implementation of legislation as a result of COVID-19. What are the risks of this when a legislation is rushed through so quickly, which as we saw this year?
Well, obviously, from my point of view, you need to be able to assess a situation and advise on it, just as it is for everybody. And it's coming as rather unexpected. I mean, if you look at the way that the response to the pandemic is rolled out, I think initially the first lockdown was very much sold to the public as a need to keep people in their homes in order to increase capacity in the NHS to actually cope with the number of people being infected. And you can rationalise that, and lots of people actually had probably a 3-month time frame in the back of their mind. They said, right, okay, look, we'll all stay at home, we'll allow people to go and actually do major construction projects to get these Nightingale hospitals constructed very, very quickly, which is an impressive piece of collaboration in itself. And at the end of that 3-month period, once we've built capacity into the NHS, then pretty much we can go back to normal. So I think if you ask people at the start of or at the end of March, when you first go into lockdown, actually, how do we assess the impact? They'll probably said, okay, well, let's get a program, let's have a look at it, and let's say, look, there's going to be a 3-month window where people are going to be, it's going to be difficult to do business, and then it should be get a bit more simple effectively, and there'll be less restraints on us. And as it's turned out, I think probably the mission has changed, for want of a better phrase, and it's now about controlling people's liberty and say, well, right, okay, there probably is enough capacity now in the NHS, but we still want to keep people at home because we want to keep the numbers of people infected down. And I think that's a change in emphasis from the government. And I think that will probably have had quite a major impact, because if I'm a contractor or somebody else trying to program a job going all the way through this year, and I make a first assessment saying we get through 3 months and then things should be a lot easier, and actually, 3 or 4 months down the line we're in another lockdown again, it makes life very, very difficult. So I suppose the legislation itself is brought in very quickly, so it takes time to actually filter through and assess it for anybody involved, whether it's a lawyer or anybody, any other stakeholder in a contract, in a construction project. The other thing that I found is that there's a lot of messaging coming on to the government saying you can't do this, you can't do that, you have to do that. And actually there's no legal backup at all, which can put you in a very difficult situation. Because you can say, oh, well, you shouldn't do this. And say, well, okay, so where does it say that in whichever rule, regulation, piece of legislation? And say, well, we haven't done that yet. So you go, okay, so you haven't done that yet, but you're telling us not to do it. So how do I feed that back into the change in legislation parameters in this building contract then? If it's not actually a change in statutes, and it's just you giving some guidance, but it's masquerading as actually law. So yeah, no, it's it's a real minefield to actually for anybody to work through. But lawyers as well try to actually, making it meaningful and concise advice to their clients, because they're just saying, well, legally, actually, you probably can carry on doing it, but there's all sorts of different angles to look at this in terms of the way that you're perceived outwardly, etc., and doing the right thing, and your PR. Yeah.
You literally did take the words out of my mouth. I feel like it has been a bit of a minefield trying to navigate all of these changes. And like you say, whether it is legislation or whether it's regulation or whether it's, just advice at that point, it's such fine tuning, but very important fine tuning, I suppose, isn't it? Now, Darren, I'm going to come to you. On this particular job with Vita that you talked about in your presentation, were things made any more difficult by the fact that as it was, a student accommodation building, there really was that firm deadline of this is when the student's going to arrive, this is when the term is going to start? Would it have been easier if it was a PRS, for example?
I think in some ways, yes, it would be easier. In some ways, it would be more difficult. I think it definitely with student accommodation, you kind of head into a particular date within a certain time frame of the year. And everybody knows generally that's always been a challenge. I guess the big question was, are any students actually going to turn up anyway? So is it worth actually continuing? The funders were kind of in the approach of, well, actually, am I going to get any money back? Because at the end of the day, it's kind of student accommodation generally from overseas students, and are they actually going to turn up anyway? And therefore, would it be better just for us to stop now anyway, and then kind of let it go on to next year? So in terms of that, I think it makes it more difficult. But what probably kind of makes it more sort of easier, if you like, is there was a deadline. It was kind of the client here definitely knew that he had to finish by a certain date, and therefore that sense of mutual benefit was really real, because there was that kind of red line, if you like, in terms of this is when we need the building. And so other projects that we've been involved in where there's not been that desire or drive to a particular date, I think it has probably led to a bit of sort of inaction or inactivity relative to kind of agreeing some kind of mutual benefit for all the parties.
It is interesting. Some people would prefer a really strict deadline. Some would prefer maybe not. It completely depends, doesn't it?
Yes.
We've got time for a few more questions with both Piet and Darren, so do please feel free to type them into the Q&A box if you'd like to ask anything. I'm going to stay with you though, Darren, because you mentioned the importance of communication. We've all talked about the importance of collaboration as well. So just how vital was it to make sure that you were communicating even when there were some of these difficult conversations to be had when things were quite uncertain and unsure?
Yeah, and that took. I think that's probably what took most of the toll on our teams, because what tends to happen within large construction contracts where there's a lot of people, you can't actually speak to directly as easily to the individuals concerned as you can to kind of the organisations that are involved. So if the organisation closes down, it's very difficult to actually talk to the individuals that are coming to your site or kind of working on your project. And that, I think that we've probably learned the most in terms of that communication and being able to kind of send through kind of notices to individuals relative to our project, you know, telling them that the sites are open, that they can come and work. So I think communication is really, really key. And the other thing that was really interesting at the beginning of this, of the pandemic was the role that social media was playing. So there was a lot of things, and this was more kind of associated with projects in city centres, really, because they were quite visible, you know, whole city centres full of nobody except construction workers. And so social media wise and the media, you know, they were kind of quite quickly jumping on the back of, if you like, contractors, because should they be working, should they not, are they complying with the rules, etc., etc. And it only takes, you know, one person on a building site with a mobile phone to take a picture of them stood kind of within a meter of 3 or 4 people, and a whole company is associated with that kind of poor behavior or that lack of social distancing. So I think that was a real challenge for us right at the beginning of the pandemic, is how do you make sure we're doing the right things consistently 100% of the time, so we don't kind of get into a social media kind of battle with people, because it was a challenge for a lot of people. I think as a construction industry, we've probably come out of this a lot better than most, to be honest, because we have had the ability to kind of keep going, and we've been blessed with that, really. So we kind of, yeah, that's relative to the communication.
Yeah, it's a really interesting point you made about social media, actually, because it's true that anyone with a phone can be a journalist now, can't they, really? Because they can snap a picture and put it on social media, and that's that. So that's a really interesting point. Piet, we'll come to you now. So you mentioned force majeure and frustration in your presentation. You must have seen a significant increase in inquiries relating to those two issues, maybe more than you'd experienced in the past when it wasn't quite so at the forefront of people's minds. Have you experienced anything like it before?
Well, I mean, yes, sometimes. And I suppose it's just indicative of what the coronavirus was, being something that was a real issue that nobody had really expected. You know, I've been doing construction law for over 20 years. I haven't spent a lot of time talking about force majeure and frustration because they're the remedies which are fairly unusual. They're not the generic type of, you know, I need to get time and money, I need some lost expense, I need an extension of time, etc. I've got a whole bunch of variations on my account, and I'm entitled to extra money, or the contractors being unreasonable and asking for an unreasonable amount of money for these. So they are very much indicative of where something has gone horribly wrong. And there have been a few contracts where, you know, for example, say you go onto a site which you expect to be absolutely fine. You've had all the petrochemical reports for that, and it looks absolutely fine. You start digging and find there's all sorts of chemicals in the ground, or a huge amount of asbestos or something like that. Or there's some other calamity within it that basically says, actually, this is now going to be markedly more expensive, and it's going to take an awful lot longer to do. And that's the time when people say, right, okay, well, how do we get around that? Because, you know, it's such a big change. Actually, this is not what I really wanted to get myself into. So is there some way to get me out of this, really? And that's where you tend to come across these sort of discussions.
Yes, absolutely, really interesting. Thank you. Now, Darren, we've had a question in from Canty Chappie, who is a former ProCon panellist. We hope you're well, Canty. He's asking if there are any extra issues with an urban site, you know, like travel arrangements for workers in the absence of public transport, for example, especially with revised phasing.
Yeah, I think there was a lot of that, a lot of big issues. You know, at the beginning of the pandemic, you weren't allowed to travel in the same van as somebody else. So you kind of, you know, how do you get all the tools and the people there? And there's some really really odd ones, as I kind of mentioned a little bit in my talk. You know, there was no hotels, for example, open, and also any kind of catering facilities. You know, we're so used to having 5 or 6 coffee shops around the corner from most of our sites, and then when all of those close, how do you feed everybody? How do you kind of So there's very much a sense of there's lots of other things that we don't normally have to think about that became really kind of important. We put some of our teams working at night because that led to the fact that we could have more people sort of being productive. It wasn't a 24-hour site, and it then had to become so we could kind of keep the site numbers up. So yeah, there's a significant amount of sort of extra issues relative to the fact that we're sort of trying to travel into the middle of a city centre.
I think the main takeaway from this year is just how quickly and how well people have been able to adapt. And I think you've summed it up really well there, Darren, in all of the different changes that you had to make, and Pete, in all of the ways you guys have had to kind of adapt your services as well and react to the year that has been 2020. Thank you, both of you, so much for answering those questions and for sparing your time this afternoon. That's all we've got time for from us, but I'm going to hand over now to Will Kersham, who is going to bring today's webinar to a close. Over to you, Will.
Thanks, Danielle. That brings us to the end of today's webinar. Sorry, I've just lost a little bit of connectivity here.
We can still hear you, Will, at least, even if we can't see you.
Well, I think it's more important that you hear me than see me. A lot of people would probably say that. But anyway, thanks, Danielle. And also thank you to both of our fantastic speakers, Pete and Darren, and everyone involved in the organisation of this webinar. And of course, thank you for watching. And as we come to the end of the year, very difficult year, I'd also like to thank Danielle and Tom and their team for a very professional approach, and also to the wonderful Alison Jeffrey for everything she has done in the organisation and keeping both ProCon Leicestershire and ProCon Nottinghamshire going in these difficult times. So a big thank you to them, and also a massive thank you to everyone else, our members and everyone who has supported us. Now, remember, you can get in touch with us if you're interested in becoming a member of ProCon by emailing us on info@procon-nottinghamshire.co.uk or info@procon-leicestershire.co.uk, or by giving us a call on 07803 126 807. This is our last webinar of 2020, but we'll be back soon with our next webinar in January. So do keep an eye out on our social media channels and website for information about how to save yourself a place. But for now, thank you for joining us. Thank you for supporting us through the year, and have a very Merry Christmas, and we'll see you in the new year shortly. Many thanks.